Good morning, colleagues. We are kicking off our roundtable discussion. We're happy to welcome you at the third St. Petersburg Legal Forum at our panel section, which will deal with the very topical issues. Issues of highly specialized, but nevertheless, which are of high value and importance for all of us. The issues of use of reserves, the legal status of jurisdiction, issues which we face, barriers that we encounter in making investments, and the way to overcome those barriers. I'm happy to welcome you. My name is Evgeny Moskov. I'm Deputy Director for the RG Department of the oil company Rosneft. For over a number of years, I have been dealing very closely with the issues of subsoil use, and I would like to believe that today we'll be able to discuss in a friendly way all those issues which are really topical for the industry. First of all, and as a moderator, I would like to make a few introductory statements, if you will, which I believe can characterize the modern state of the modern Russian legislature, and to identify the key issues, venues for its development. The subsoil laws in Russia dates back to 20 years ago. All those 20 years that the law on use of subsoil has been in existence, we have been accumulating the court practice, the legal application practice, and dispute resolution. We also have gained experience in sub-laws, and now we can speak about the formed institutes of subsoil use, and we should say that our legislation is not static. The new institutions which come in existence often recently is the Institute of the Subsoil of Strategic Importance, the issues relating to continental shelf results, which can be developed only by the state-owned companies, and which is basically make the foundation for the development of adjacent development of legal acts like the customary custom laws and taxation laws over the 20 years which have elapsed in practice and in the literature in the courts. So we have been conducting discussions as to how the public and the private parties should coordinate their activities. The court practice looks at in a varying way onto the practice of production sharing. There are a number of approaches, schools of thought, which deal with the, but nevertheless, the Russian laws over the last 20 years sticks loyal to the principle of protection of state interests, national interests, and implementation of those constitutional principles of use of subsoil, which were made as a foundation of our constitution back in 1990. No matter how often we speak about the need for a global or even revolutionary review of the local legislation about use of subsoil, an attempt was made by the developers of the new, civil code developers. So if you look at the first norms which were proposed as in the first draft, well, as a matter of fact, the attempt was made to bring the subsoil use into the civil law, and to start the state registration of papers of plots of land of subsoil plots. All those attempts were confronted by the business community, by the professional community, and now the civil code refers the subsoil laws to a special branch of law and gives priority to the special legislature. So this is a discussion about the balance between the private interest and the state in the public interest is as old as the law on subsoil use, and every year with the emergence of the new institutions it becomes more and more active. I would like to hope that we'll have a productive discussion session, and our addresses, keynote presentations will be deal with it. Let me now get back to the agenda of our discussion, and in accordance with the rules of procedure, we will have 4 keynote addresses to be made by our speakers. Having the time budget which the organizers give us, we have to stick to 1.5 hours time slot, and I think that each speaker may have 10 to 15 minutes, and following which we will have a chance to discuss the presentations made by individual speakers. Ladies and gentlemen, the first presentation at the panel session will be given to our guests, General Secretary of the Guinea, Mr. Curtis. He's
Allô, allô, ok. Je remercie d'être présent ici.
Я благодарю всех за то, что мне дала возможность здесь присутствовать.
À l'International Legal Forum.
Well, at this St. Petersburg Legal Forum, in my capacity as the Deputy Minister for Mineral Resource Development of the Republic of Guinea, I represent the Ministry of Mining, and I am also responsible for everything which is related to the mining industry. Where the Guinea finds itself? It's in the Western Africa zone. In the north, it borders with Senegal. In the south, with Liberia, and in the east, it borders Côte d'Ivoire and the Republic of Mali. The population of Guinea is about 11 million people, and the majority of the population are Muslims. The Republic of Guinea is rich with mineral resources, which are basically supposed to be mined. Especially is known for its boasts about 40 million tons in reserves, and it is also known for a huge resource of deposits of iron ore. It is also known for its deposits of diamonds. And there are several million deposits of gold containing ore to be found in the subsoil of our republic. We also have high hopes to find and develop the deposits of manganese and uranium and copper as well. Guinea has the Society for society which is connected with the Russian company Subsoil, and which deals with the production of mineral resources in the Republic. So, why Is it important for us to discuss the issues of balance, striking a balance between the public and the private interests? The state, which we represent here, possesses a lot of mineral resources, and the authority to use it lies with the state. However, quite often we do not have, the state does not have the means or the ways of the finance to develop those resources. So there is also the risk of transfer of the production of the value. There is a risk of transfer of value or loss of the control on the state on the on top of that, the state also believes that it does not get all the benefits as it is expected to get from the production of mineral resources as intended to receive. As a rule, those who invest in the mining industry have huge financial capabilities, and they have the technology which is used to develop the mineral resources. That's why the objective is to combine the public interest and the private interest which invest in the mining industry. What solution could be found for this issue? To start with, as in everything which deals with business relations, mutual trust and confidence is of paramount importance. С одной стороны, инвестор должен быть уверен достаточно в том, что он сможет получить прибыль и инвестировать ее, вывести ее из страны. Окей. To get back the money from which investing in this sector, and while the state should be sure that it would be able to get all the benefits from the production of the mineral resources, which it gives the right to do to a foreign investor. And the investor should also be sure, and while he is concerned about the safety of the capital which they invest in their project. So it is necessary that those finances which have been invested in the business should be protected by the state. At the same time, investor should get the benefit, the profit, which he expected to get when he begins his investments. it is important that the mining industry should be have the activity enough which would generate profit for the investor. And with this aim in view, it is necessary to have appropriate legal, framework, to have a legal framework in place which would take care of the interest of the public interest and the private interest from risks available in this industry. Negotiations should be conducted before any investments are made, and it is the Minister of the Mining who is supposed to conduct such negotiations on the public side. The society, the company which invests, and the partners which would be involved in the development of the project, of the mineral resource. It is also important that the state, which participates in the negotiations before investments are made, should have enough political will to implement the agreements to be reached from potential risks. It is also important to include into the contract the provision which would provide for the redevelopment of those sites where natural resources are produced so that they can be used again and again in the future. It is important that the company should be, investment company should be responsible for rehabilitation procedure when the project is done and completed. Because it is obviously necessary that quite often mining business leaves a very heavy and damaging environmental print once many projects are completed. That's why rehabilitation of the mineral sites is of paramount importance. If all those, conditions are taken care of, it is possible to arrive at a destination where the interests of all the participating parties are met. I thank you for your attention, for your patient hearing.
Mr. General Secretary, thank you very much for your presentation. I believe that this message really confirms to the thesis that we have looked at initially as to the issues which arise in this area, irrespective of the legal system or the jurisdiction in modern days in the context of the development of the mining or oil and gas industry. And this presentation is a vivid example which states basically that all the issues that we will look at afterwards are global in their nature, and I thank once again our speaker for the presentation. And now please the audience, if you do have questions to Mr. General Secretary, come up with those right away. It's still morning, let us be more active. Perhaps there are any questions or remarks from the floor. Well, perhaps by the end of the section or panel discussion we'll draw a kind of bottom line and have the discussion, the general discussion. So if I may, I would like to give you our next keynote addresser, Mr. Laurie McFadden, a partner in the Freshfields company, who will speak at our panel session covering a very relevant set of issues relating to foreign investments in the subsoil sector and issues of the so-called resource nationalism. I think it will be very interesting. So please.
Good morning, everyone. My name's Laurie McFadden. I head up our Global Energy and Natural Resources Group. I'm based in London, but I'm Canadian, so I share with Russians love of forests, rivers, lakes, and ice hockey. Always enjoyed the rivalry with Russia on the ice. The subject I am talking about today is a continuation of the subject introduced, the balance between private and public interests in resources. And what I would like to do is to look quickly at some of the ways in which states around the world are asserting their interests in resources and some of the ways in which investors are responding. Now, the tension between the public and private interests in resources has always been with us. It has been most dramatically evidenced by the expropriations that have taken place around the world. Most recently, since the global financial crisis, governments around the world, including Western governments, have been trying to seek whatever revenues they can, and the booming extractives industry has been an easy political prey for them. We also have the continuation of the unpredictability of policy and the unpredictability of regimes in a number of jurisdictions where resources are key. So what I'd like to look at first is just how important the issue of resource nationalism is to companies. Ernst Young in, let's see, I'm not sure I can change the slides.
Презентацию, коллеги.
Yeah. It's different. And let's see if someone can get the slides on board. But Ernst Young publishes an annual survey of their interviews of leading mining executives around the world. And that survey ranks resource nationalism as the #1 global risk that mining executives see when they're conducting their risk and benefits assessments of any projects. It's interesting to note that as recently as 2008, mining executives rated resource nationalism as only the 8th biggest risk that they face. So you can see it has really moved up the agenda in people's minds. So what are the different ways in which states are asserting their interests? We've talked about expropriation, and that's historically there have been many cases, but we've seen a very sizable expropriation this year with Argentina's expropriation of the Repsol YPF interest, and Repsol is currently bringing a claim in excess of 10 billion in that regard. We're also seeing that more countries are, through their domestic legislation, requiring that states have a share of resource companies. And so we're seeing in the DRC, we're seeing in Guinea, as well as historically has been Chile, legislation requiring interests in certain minerals and resource companies, so that, for example, in some countries, 10 to 15% must be owned by the state. We're also seeing restrictions on foreign ownership, of course, and they take many different forms. My home country, Canada, has recently brought in restrictions in relation to the size of interest which state-owned entities can have in the oil sands, following on from the CNOOC takeover of Nexen. The other thing we're seeing states doing is looking at whether or not they can revoke concessions or force a renegotiation of concessions where circumstances have changed. Sometimes we're seeing states rely on what to investors seem to be fairly immaterial breaches of either the concessions or of the concessions or of relevant regulations, such as environmental regulations, in order to force a renegotiation. And this is a concern that investors have. The other method that we're seeing states use, of course, is taxation. And taxation can take many different forms. One-off bonus payments are common in the oil industry when, for example, certain production targets are achieved. Royalties, we've seen much increased royalty rates globally, both in Western and emerging nations. We've seen higher rates of corporate income tax being imposed on companies in the resource industry, such as in Nigeria and the oil and gas industry. We're seeing resource rent taxes, where super taxes are being imposed on what are perceived as super profits. Australia's super mining tax has been an example of that, which has caused a lot of difficulty for Australian mining companies. We're also seeing more examples of exit taxes, where investors are selling off their interests. Governments are trying to tax the capital gain that they've incurred, even if it's done, the capital gain is being achieved offshore. And we've seen on the Heritage sale of its assets in Uganda, the Uganda government imposing a capital gains tax, which Heritage Oil is disputing by way of arbitration. We're also seeing a number of cases where governments are trying to reduce the losses which companies can claim against the profits. So a number of jurisdictions, I think Ghana, Kazakhstan, Tanzania, have restricted the losses that are being incurred at one mining site, and they're not allowing those losses to be offset against profits at another mining site in the same country. Other ways in which we see states globally asserting their interest is through requiring forced expenditure. Sometimes investors volunteer the expenditure, but in many cases the states are requiring it. Infrastructure investments are common. Social investments, whether they're in schools, in hospitals, or in training of labor forces, is quite a common requirement now. Local supply requirements are increasingly being used. In Brazil, in the oil and gas industry, your oil and gas concession will stipulate the minimum percentage of local goods and services that you must use in the expenditures you're doing on the project. Local labor requirements, Egypt requires you to be restricted to only 10% of your employees can be foreign employees. And if you want to exceed that, there are arrangements that you must put in place whereby you are in effect training local employees to replace that foreign employee. One of the things we see increasingly is that what starts off in one jurisdiction is then copied in other jurisdictions. And the next one is an example, mandated local refining or processing. We are seeing many more countries follow a certain example, such as in Indonesia, where refining and processing is required to be conducted in certain minerals in country. Now this, of course, raises the costs often for companies, and it also can raise the risk profile. There are other examples, export restrictions and forcing companies to meet domestic market supply can force lower prices on investors. And it's just another way in which states assert their interests. And we've historically seen capital and exchange controls used as well. One of the other ways that investors are increasingly concerned about is where they have a state-owned entity as a local partner. We're often seeing the state-owned entity pursuing non-commercial objectives that may not be in the interest of the joint venture, but they may be in the interest of the state. And we're seeing that sort of behavior, which can cause considerable delays or extra costs for investors. So what are private investors doing in order to respond to these, and what should they be doing? One of the things that has been touched on earlier has been the importance of mutual trust and confidence in the relationship between investors and governments. One of the things investors, I think, are getting better at is to describe the benefits they bring to countries, both the direct and indirect benefits. But one of the things that they need to continue to be much better at is also being upfront and transparent about the various risks that projects bring with them. Because in many cases, projects are being sold to governments based on a very optimistic scenario. And when the risks actually that are incumbent on these projects actually are incurred, and there are delays, or the reservoir of oil and gas doesn't prove to be as sizable as it had been predicted to be, there's a lot of disappointment. And I think that what really needs to happen is that there is a much better and frank discussion of the risks and benefits these projects bring from the outset. We're also seeing investors endeavor to create valuable local presences by their investments in infrastructure, jobs, and social investments as a way in which they are seen as contributing to the community, and then hopefully being subject to a more beneficial view from the government as to their participation. The other thing we're seeing is the alignment of interests with the state, either through state-owned entities being partners or through having local partners. And this, of course, again, helps investors perhaps protect themselves, perhaps align their interests with the state. Political risk is certainly much higher up the agenda for investors than it used to be. There is a new industry of political risk advisors, which has certainly grown considerably in the last number of years as resource nationalism has become an increasing issue. But people are not only assessing the risk on the way in, but they're also assessing on an ongoing basis the political risk that their investment faces in a much more detailed and sophisticated way than in which they did in the past. Finally, taking a lawyer's view, there's also the international agreements and treaties which are there to help investors protect their interests. Bilateral investment treaties will be well known to you. There are approximately 3,000 of these in existence now, and they give investors an opportunity to make claims against states for unfair or discriminatory treatment. The Energy Charter Treaty is another example of that type of arrangement. Stabilization provisions have always been something that the industry has sought and have in many cases been increasingly difficult to achieve in negotiations with governments. And those provisions endeavor to ensure that any changes of law in the future or increases in tax rates won't affect a particular project, and therefore that the investment case continues to be sustained and not undermined by changes in law. And finally, we're certainly seeing a very focused look at what dispute resolution mechanisms are agreed, from the choice of law to whether or not the local courts will be neutral, fair, and will deliver timely judgments if you need to have a dispute. And also people looking at what international arbitration forums are available. So just in conclusion, I think that the comment again that has been stressed earlier, the mutual trust and confidence that has to be built up between the governments and private investors is key. And really aiming for an open discussion of the risk and benefits that these projects can bring, and trying to appropriately allocate those risks and benefits is very important.
Thank you so much for your presentation. Being the moderator of the panel discussion, I would like to ask a question to our keynote speaker. Would you perhaps believe that the notion of resource nationalism is putting all the government policies in the negative area? That is, all that the government does towards investors becomes somewhat negative. Well, in the Russian language, it sounds quite so.
Resource nationalism certainly has those connotations of a negative approach, and I think it's an approach that has been used by investors and rather carelessly. I think that the real discussion is around how do you appropriately balance the interests between public in its own resources and between investors whose capital is being sought to invest in the development of those resources. And this is why I think that in the past there has been often an absence of this mutual trust and confidence which is necessary to have a long-term investment. And I think talking in terms of the balancing of interests is a much more appropriate way to talk about it than in the context of resource nationalism. The resources are obviously the resources of the state. The state must benefit from those resources, and its people and the political system will ensure that those interests need to be protected. So I think you're absolutely right that perhaps we should try and avoid the use of the word resource nationalism because I think those words have an unfortunate connotation.
Коллеги, может быть, есть...
Are there any questions from the floor? You're welcome with those. Please do use microphones because we are running simultaneous interpretation here.
My name is Irina Palishvili. I'm oil and gas lawyer from Kiev, Ukraine. And you were talking about trust between the government and investor. But these projects are long-term. And the investor stays the same, but the government's changed. Sometimes they change every 2 years, like in Ukraine, for example. And one of the biggest publicized cases in Ukraine was when foreign investor, U.S. company Venko, won a PSA tender, signed the PSA with one government, then the government changed and the trust disappeared, so the next government canceled the PSA, which ended up in the international arbitration. I was an expert in this international arbitration in Stockholm, and your law firm represented the government of Ukraine in this arbitration. So how do you hedge your risks of government change and, completely opposite attitude of the new government towards the project? That's first question. And the second question is how broadly you define expropriation, because these days many governments, they have been already in international arbitrations under ICSID, under Energy Charter. They don't do expropriation straightforward. They become more sophisticated and they do hidden expropriation. So what would be the response of international arbitrations of investors towards this, not exactly expropriation, but a broader, more sort of hidden expropriation? Thank you.
Thank you for your questions. If I start with the second question first, yes, I do agree that states have become much more sophisticated. The examples of outright expropriation are getting fewer, but as we've seen with the Repsol case, they do continue in some jurisdictions. But the list I put up indicates a number of ways in which states are trying to benefit from their resources, which can be viewed as indirect or subtle means of expropriation or ways of increasing the share of the revenues generated by those resources. And in some cases, those are legitimate. And for example, increasing tax rates, if done generally and on a non-discriminatory basis, can be legitimate. In other cases, they may infringe the agreements that have been put in place. So taking the first question now, how do investors protect themselves? what they do is at the outset, they spend a lot of time, and if they're well advised, trying to structure their arrangements in the best way possible. One, to try and ensure that they have the best bilateral investment treaty protection, which can provide them with, depending on the bilateral investment treaty, protection for different types of expropriation or prejudicial behavior in terms of their interests. Now, not all bilateral investment treaties, as you well know, are the same. Some offer very little protection, some are much more beneficial, and so people will try and structure their arrangements that way. So they will also try and negotiate their concession in a way which will give them protection. But in practice, they have to look to other non-legal methods as well of hedging their investment. Some of that is trying to ensure that they structure the arrangement so they get as early a payback as possible. So they're not exposed for 15 or 20 years if they can negotiate that sort of arrangement. So you see people focusing on a near term to avoid that long-term exposure. Other things people do are to try and build up a valuable local presence in the country where they're seen as a good contributor, a good investor to the country. So it's more difficult for where there's a change in regime for the governments to attack them or to get the political backing to attack the investors. If they're seen as, good investors, they have been environmentally responsible, they've offered training and jobs to local people, they haven't just exported the materials, used only foreign employees, being careless about the environment, they have a much better chance of enduring those regime changes. That sort of risk will not be eliminated, and I think that Ernst Young study, which ranks it as this risk as the number one risk that executives face when they're looking at projects, echoes there is no magic solution. There's just a number of things that a good investor can do to help improve their chances. Well, political risk insurance is available, and you can occasionally find it. The difficulty is getting the coverage you need, getting it for the duration of the investment, and getting it in an amount that will be sufficient, and from a provider that you can rely on that will be around. So people do look at political risk insurance, but there is not a single solution.
Еще вопросы, будьте добры.
More questions, if there are any. Good morning. I seek pardon. My colleague were supposed to participate in another working group discussions, which was associated with WTO activities, but I may present myself. First Deputy Minister for Natural Resources of Ecology of the Russian Federation. I am this Nikolai Popov is my name. I particularly liked the idea expressed by one of the speakers about the necessity, importance to provide for stable legislation in the area of subsoil use. What I am trying to say, what I'm trying to get at, quite often it happens in this way that the development of our legislation is in the form of a quick response to specific situation, to there's a specific issue which we currently face. Sometimes it is done to suit somebody's interests of some parties. Unfortunately, we lack a comprehensive approach towards the improvement of the legislation of the Russian Federation per se, and in the area of the subsoil use in particular. Yes, indeed, we have in the area of the subsoil use a number of what we call grandfathering provisions, which influence the stability of the law and application of the legislation. But at the same time, we should also not lose the sight of the fact that legislation, especially tax legislation, changes quite often. And over the period of, say, if you open the any law, say books, you will see that over the period of existence of the Russian Federation in the new form, we have accepted more than 5,500 pieces of legislation. But we lack to understand, to analyze how efficient they are in terms of application. Over the last year, in particular, as many as 38 pieces of legislation were adopted, modifying, amending the tax legislation. It is a testament to the fact that we constantly change the rules of the game. And I quite often compare it with the situation that if we invite, for example, to Russia other football teams to play football, but we keep on changing the rules of the football game. Do you think that many football teams who would like to come to Russia to play football here? The same goes for the investment activity in this country. This is this frequent change of legislation, sometimes quite situational, sometimes not justified, results in the fly of capital from Russia. Minimization of issues relating to the investment activities in Russia. That's why I would like to support the idea that the stability of legislation is of not as a positive, phenomenon in this area. Thank you for this comment.
I wholeheartedly agree that stability is a very, very important aspect of any investor's investment decision. And they try and achieve stability in many different ways, but they certainly look at the different regimes. And certainly Russia is not a bad example of consistent regime rule changes. There are many more difficult jurisdictions, and we've seen in the West, a lot of the Western governments have certainly changed the rules in ways in which have undermined the investment cases for a number of companies. So it is a constant issue for the industry, in particular because of the huge sums of money that need to be invested and the time periods over which they need in order to achieve a proper return for those investments.
Well, with your permission, considering our budget of time, let's get on with our agenda. Perhaps at the end of the they will have more time for exchange of our views. We have already, I think, identified some of the issues which we may want to address. But now let me give the floor to Professor Hiroshi Oda, who is a professor in law. He specializes in Russian and Japanese trade law. You have the floor, Professor. Ladies and gentlemen, good afternoon. For me, it's a great importance to be with you today. Unfortunately, I will have to switch to not to Japanese but to English language.
Background I have been working on the Sakhalin 1 project since the 1990s for Japanese companies, and I occasionally advise Sakhalin 2 on a spot basis. So I've been watching Russian subsoil law for more than 20 years. So today I was asked to comment on the Russian subsoil regulation. Subsoil regulation. So please let me focus on the Russian subsoil law. Now it's my pleasure to tell you that now Russian companies, upstream oil companies, they have become more sort of open and we Japanese companies have been invited to join force in various projects, upstream projects in Sakhalin and the northern part of Russia, like Kara Sea and other places. That's fine. And actually, Mr. Sechin of Rosneft, he visited Japan earlier this year, sometime in March, and discussed various possible projects with Japanese companies. He also acknowledged that the Russian companies, to a certain extent, they have some problem in finance and the technology, and they welcome the participation of foreign IOCs in their projects. That's a good news. Now the problem is that the Russian legal infrastructure does not necessarily support this. The chairman has already mentioned the latest, not latest, 2008 law on the investment in strategic sectors, which, according to which companies who are entitled to develop the continental shelf fields, they have to have a 5 years experience, and plus they have to have more than 50%, over 50% Russian Federation capital. And that leaves well, that means that there are only 2 companies which are eligible for such a project. But then if you want to invite foreign companies, you cannot really invite foreign companies just for technical assistance or finance. Foreign companies would, of course, prefer more sort of a commitment to the project. But under the current legislation, this is not possible. But there have been proposals to liberalize this restriction, but so far it has not been adopted by the parliament. The other thing is, by the way, there is a threshold of the foreign participation in companies working on the fields with a federal significance, and that ceiling is also very low. It has been raised once, but then we prefer to have it a little bit higher. That's one thing. Now, there was a comment from the floor about the foreseeability or predictability of the law. According to the same 2008 law on the strategic investment, actually, if in the process of exploration a reserve has been found, and this reserve is qualifies as a the field of federal significance, then even if the foreign company has a combined license of exploration and development, there is no guarantee that this foreign company can continue. They have to have another permission of the government, which may make the initial investment by a foreign company a waste. So that sort of discourages foreign companies. That's a problem. Now, the next point is that, as I mentioned, I've been working on this subsoil thing for over 20 years, and I've seen all the changes. Now, some changes are positive, but the problem is that the basis of the subsoil legislation, that is a subsoil law which was enacted in the early 1990s. It has been amended several times, and the latest amendment took place a couple of days ago. But it hasn't been substantially changed, except for after the 2008 strategic investment law. And then there are other laws like a law on the continental shelf and etc., and production sharing law. These kind of laws, they have been there for many years, but there doesn't seem to be much coordination between these laws, and these laws have not been sort of updated. So that brings some confusion to foreign investors. And we've been discussing this balancing of the public and the private interests in the subsoil use. Now, for that, I would have thought the projects like production sharing would be one of the answers. But the problem is that with production sharing, I mean, the Russian government has well, we have 3 production sharing agreements with Russia, I mean, foreign investors, the Sakhalin-1, 2, and Hariaga. The problem is that these projects were signed before the enactment of the production sharing law. They are all grandfathered. But then there hasn't been any production sharing project since the enactment of the law in 1995. And the fate of the production sharing is unclear because some people were hostile to production sharing. And but it is a good way of proceeding, particularly balancing public and private interests and subsoil resources. So I think, well, I read in the year 2008 law that I thought the production sharing law was dead, but then I saw a reference to production sharing in the 2008 law. So it is still alive, but just. So I think this production sharing should be sort of reviewed and maybe developed, improved and developed in the future. Particularly for projects in the difficult areas like offshore, deep sea areas. Talking about confusion or foreseeability, the Russian environmental law is rather chaotic. And it's not only environmental law in general, but for instance, when we develop projects, we need environmental assessment, etc., all sorts of procedures. But the procedure is not properly regulated by the law. For instance, there is a institution called the State Environmental Review, Государственная экологическая экспертиза. But this is not the same as the environmental assessment, but it's misleading. And I think the legislature at the time of adopting the legislation, the legislature was confused. They didn't understand the concept of the of the environmental assessment, and this confusion still continues, and it is very difficult for foreign investors to proceed with the project and build all these installations because they come across all sorts of difficult environmental and ambiguous provisions of environmental law. So that should be rectified. And actually, the ambiguity of the environmental law can be sometimes abused, like in some incidents which happened in the 2000s. Now, finally, I would like to mention the system of dispute settlement. I think the chairman mentioned that too. But the dispute settlement in subsoil project, this is very important. And the problem is that the subsoil law provides basically for the state court to settle disputes between investor and the user of subsoil and the state. But there is a provision in that law which allows the parties to agree to arbitration, Trecheski suit, arbitration. That is fine. That looks fine. But then, according to the law on production sharing, arbitration is one of the methods, available methods. That is fine. But the production sharing law limits the arbitration to имущественные отношения, that's the proprietary property disputes. So there is some discrepancy between these two laws. In addition, talking about the public interest, there is a trend these days in arbitration law, in the practice of the arbitration court. That's the arbitrage suit, not the arbitration institution. The court practice in Russia tends to is moving towards the narrowing the scope of arbitration vis-a-vis state courts. That means that in some cases you agree to arbitration, the parties agree to arbitration, but then after the award was given, then the losing party may go to Russian court and say that this award is not valid. It should be set aside because this involves public interest, and if public interest is involved, then arbitration should not be allowed. They should go to the parties should go to the state court. So this happens in general in Russia, And my concern is that, and this is the, I just read the commentary on the production sharing law. It says that the production sharing, there is a very important public interest there. So that kind of concern may lead, that kind of perception may lead to the narrowing of the scope of arbitration and expand the scope of the state court jurisdiction. So, and that will be a great serious concern for foreign investors. So thank you very much.
Спасибо, господин Хироши, за
Thank you, Mr. Hiroshi, for your speech. I would like to make some comments regarding that. When we say that subsoil legislation is not meeting the interests of investors in an adequate way, perhaps we could or could not disagree. I would like to express my personal position as to our current status to this effect with respect to the continental shelf. This is, by essence, a new strategic oil and gas province for the Russian Federation. We're just beginning to tap that kind of resource. Looking globally, most of the countries which welcome investors do try to have the maximum possible level of state participation in this particular area. And I would say that currently the legislation that was adopted back in 2009, opening the way for companies to work on the Russian continental shelf, is working, and in some cases quite efficiently. Rosneft has signed agreements on strategic cooperation with one of the global leading companies within the framework of existing legislation on the continental shelf. Perhaps talking about its inefficiency, we should say that this is not exactly so. There is, of course, a lot of room for improvement in terms of rights of investors. And here we come to the issue of product sharing agreements. In your opinion, do you think it is the instrument which gives more balance to that area? Looking at practices in the PSA area in Russia, the balance was not achieved. We listened during the plenary session of this legal forum to a number of presentations which underlined the need to develop our own domestic jurisdiction, which would give protection to investors. Would you perhaps believe that the issues which relate to the use of national subsoil resources should be considered in national courts of law? So we are usually in favor of commercial arbitration with seats somewhere abroad, but wouldn't it be better to say that those cases should be heard domestically?
Now, first, the continental shelf, investment in the continental shelf. Yes, it has just started, although we have done some in the offshore Sakhalin, but there are more difficult areas. And I fully agree that now foreign companies are allowed to participate, but participating not really in a sort of on an equal footing, but in a sort of a subsidiary manner. So that can be that balance can be improved. That's the first thing. The second is the dispute settlement. Oh, sorry, production sharing. Now, production sharing. Well, I must admit that the production sharing in the 1990s may not. Well, it was based on the oil price of how much was that? $12 or $15. It was based on that calculation, and then in the even in the 1990s, oil prices started to pick up. So in the end, you might have Russians might have thought that the balance is not really, it's really in favor of foreign investors, or foreign investors are actually exploiting the Russians. That's for sure. But On the other hand, there are some mechanisms within the production sharing agreement which sort of take into account the changes which took place or take place during the period of the production sharing agreement. And that could have been utilized in a better way. So, and the production sharing is a more sort of flexible manner in which you can sort of adjust to changing circumstances rather than these licensing agreements and other things. So I still think that there is a room for production sharing, or even more sort of potential for the cooperation of foreign and Russian companies in the subsoil area. And the third is the dispute settlement. This is a very difficult area, but basically, with due respect to the arbitrage suit here, in general, if a dispute between the host country and investor is to be handled by the court of the host country, you cannot, well, our perception is that we cannot really expect the fair judgment. So it's better to go to a neutral venue, and that is international arbitration. Or you can, but Russia is not a signatory to exceed, so you cannot go there. So basically, we have to go to some places like Stockholm or ICC. That is fine, but I think my view is that in Russia there is a certain sort of perception that the arbitration, being a private institution based on the party autonomy, it should not be regarded in the same level, on the same level as the state courts, which means that the state courts enjoy prerogative power, whereas the arbitration, this is merely a mere pure private institution. And so, but the arbitration, commercial arbitration, has many advantages as compared to state courts, and I think there should be an opportunity left for commercial arbitration to handle disputes regarding subsoil. Of course, if it comes to problems like license, revocation of license, that kind of disputes, that has to be handled by the court. That's for sure. But for other disputes, which regarding contracts, which both parties entered, the state entered as a private business entity, commercial arbitration is the most suitable forum. Thank you very much.
Большое спасибо. Есть ли еще комментарии?
Thank you very much. Any other comments or questions from the floor? Yes, please. Do use the microphone. I would like to ask a question to Mr. Hiroshi. Now we see that in legal practices and in the relations between federal executive bodies and commercial entities, there is an issue discussed as to the possibility of expansion of the persons or entities which could be allowed to pursue subsoil projects in the continental shelf, with a possible guarantee to a subsoil user in case of discovery, the guarantee of inclusion of this company or entity into the producing consortium afterwards. In your opinion, well, rather, what is your attitude towards the expansion of this list of the companies or entities which are allowed into those projects?
I heard of that proposal, and actually the current system is that Well, it's about my second topic. That is the when somebody a foreign company finds a reserve, discovers a reserve, but if it qualifies as a strategic field or field of federal significance, then they cannot proceed without the permission of the government. But in the current system is that they may be compensated. But the compensation is, of course, determined by the government, and there's no. I forgot the wording of the statute, but it looked rather narrow. So you cannot, foreign investors cannot really recover all the expenses they have invested. So that's bad. That's bad. And I think your proposal that is to let at least there has to be some Russian companies proceeding with the project, but the foreign investor will participate as a consortium member in it. I think that's much better than the current arrangement. And I think if that happens, that will be much better.
С вашего позволения, мы тогда у нас уже...
We are slightly coming to the end of our panel discussion. I would like to give the floor to our last but not least speaker, Mr. Tolubensky, the Director for Legal Issues and GR of Nordgold. Good morning. It's an honor to speak at this panel discussion. Nordgold used to be part of Severstal, was its gold producing arm. Now we are an independent Dutch company, and we are working in 9 projects in 4 countries: Russia, Kazakhstan, Guinea, and Burkina Faso. I am delighted that I have the chance to speak last to conclude this panel discussion. I will not reiterate on what had been said. I would rather describe the trends which we see in the industry to better understand our legal realities. Then I will speak about impediments to investments and to the work that we do now. And thirdly, I will speak about a couple of major trends, mainly resource nationalism. The issue is not new, but I would like to describe my view of the development in this area in the years to come. And the most recent emerging trend, which might grow into a problem, that is environmental issues. This is quite troublesome for some of the companies and the projects, and I believe that this trend is gaining momentum, and we have to come up with some preliminary solutions to that problem, and perhaps I will speak on some other issues too. Well, first of all, can I have my presentation on the screen, please? 2012 demonstrated that there is a growing number of contradictions in the mining industry. Mining industry being production of mineral resources, less oil and gas, which is an industry by itself. And those growing contradictions are manifested in various aspects, starting from the growth of rate of mineral rent, not only in mature economies such as Mr. McFadden described, but also in many other countries. And in South African Republic, there were major strikes with victims, and the 4 months of this year have contributed to this set of contradictions. One of the largest global companies, Anglo-American, has closed 4 mines in the South African Republic, which were home to the strikes. Rio Tinto wrote off $14 billion. And just in Chile, they postponed projects for $39 billion. That is to appreciate the scale of contradiction and instability which is now inherent for our industry. The industry is indeed in a very challenging situation. First and foremost, we see that prices are dropping globally in many commodity sectors. Prices are increasingly volatile. Secondly, there is a problem with demand. The quality of resources is deteriorating, and within this context of lack of clarity, it becomes a major challenge to bring in investors. Investors would rather collect dividends from such projects as opposed to being strategic investors. Relations with stakeholders are becoming increasingly troublesome, and this concept of balancing of public and private interests should be further developed. That is to say that we have come to the point when relations to local communities, to staff, have become very important, and that dictates that we should rework our attitudes and approaches in this area into a kind of concept of sustainable development to be used across the board. Perhaps you've seen this Avatar movie, and their business model of mineral resources production is not unique. It can be seen on this planet in many localities. So we have to be increasingly aware of the needs and demands of local communities. The problem has become really global. And there is more focus on the environmental issues too. That is also an inherent part of the mining industry now. At this slide, I tried to show the findings of a study which studied the barriers and the problems in the mining industry. I left out Russia from this list, and I took just Canada, Brazil, South African Republic, Australia, Indonesia, and China in order to single out trends, and then for you to see how relevant are those for Russia. I think they are. 11 criteria have been selected. And the common feature for all those countries, despite all the differences in its economic development, is particularly the resource nationalism, limitation of foreign investments, influx, lack of guarantees for plots of land, and the rights for lands of Aboriginal peoples. Those are very pronounced in all those countries. Now I'd like to say a few words, and since I'm pressed for time, just indeed a few words about resource nationalism. It is indeed a very burning issue for the industry. It has made quite a progress in terms of its criticality over the 5 years. Now it is a very strong trend. Mr. McFadden has spoken very brightly about the manifestations of nationalism. I would like to additionally emphasize several more problems here. That is taxation, either increasing the rate of mineral extraction tax or royalty. Just following the example of Canada, I can cite Indonesia, which increased their royalty levels up to 10% right away. The second issue is the mandatory participation in the capital of the company. Usually that is very relevant for emerging economies, and percentages can be various: 10, 15, 35, 40. A very good example is Indonesia, which last year mandated that mining sector companies working in Indonesia for more than 10 years will have to decrease their share to 49%. That is, the rest should be transferred to the state. This is a very strong trend. And then the local content. Local content is about the mandatory requirements in terms of purchases and works and services in the local market, or the mandatory sales volumes to the domestic consumers and refining requirements. Just look at Kazakhstan. Starting 2012, they banned exports of gold from the country, and they believe that refined gold should only be produced in Kazakhstan. And of course, this is achievable, but the rules now dictate that all the refining should be done domestically in Kazakhstan. Regarding my opinion of the resource nationalism trend in the future. First of all, I'd like to give you a very interesting example of Ecuador. In 2008, they suspended for half a year all the licenses for geological exploration. After that, 80% of licenses were revoked and others postponed. The president of Ecuador increased royalty from 3 to 8% and windfall profit tax all the way to 70%. And this is what it ended up with. Next year, gold production dropped drastically, and it did not recover up to now.
What does it tell us of? Despite the fact that there is no strong denial of this trend, the governments continue to keep up to their positions about the mandatory role. We do not see any reduction of the tax rates, but still we are coming to the close end of the super cycle. From year to year, the prices for raw materials were going up, and in this connection, it is obvious that in the new situation, we'll see the rejection of the policy of radical resource nationalism. External foreign gold extraction companies or mining companies, like as we discussed with, are closing down their investment projects. They are delaying implementation of their project, and in these conditions, companies are getting, say, the chance to choose between those states which offer better conditions and better terms, and who offer more alluring or attractive positions. And in a short time, I see that the states will have, governments will have to rethink their policy vis-a-vis the resource and nationalism, and in any case, they should think about their investment attractiveness. The other part of the coin is that the developing countries in the situation of the crisis are focusing their attention relating to the curbs on repatriation of the profits. Curbs on repatriation. There will be more demands made or burden made on the say social sphere. They will, the governments will take actions in preventing deterioration of the social situation. So this is our plight. When the market is fine, then the government says, okay, you are doing fine, share with us your profits. But when the market is bad, the government tells us, be socially responsible. So this is the kind of the risks which should be also not lose sight of, and which will face it. What will happen to those deferred and postponed projects? The companies quite rarely denounce the projects, but they keep on, they have the license issued for a limited, specified period of time, and I think that the legal guys will have many work to do as to how they will have to reformulate the provisions of the license so that companies can keep their licenses in the situation when projects are delayed in terms of the implementation. About the limitation, I would be pleased to respond to any questions relating to the limitations of the foreign investments. But I would like now to say a few words about the environmental issues. There are three aspects which I would like to highlight at the beginning, in the middle of the project, and the end of the project. There are always sufficient number of problems, no matter where we stand in terms of the implementation of the product. We, legal advisors of the company, should be more serious in treating environmental issues. There are many examples to invoke in this respect. Chile in April 2013, the court in Chile suspended activity of the new gold extracting mine, Pascua Lama, with investment was project was 8.5 billion US dollars, and the grounds were the placement of the local statement of local communities that the development of the operations destroys local glaciers and deteriorates the system of water supply in the country. And then in Peru, in January 2003, implementations of 135 projects for the total cost of $7.5 billion were suspended since the ecological authorities of the government were, delaying, dragging on in terms of pronouncing their opinion on the assessment. So that's why I want to once again emphasize that lawyers, legal advisors of the companies should pay more and more attention to the environmental aspects of the operation of their companies. The General Secretary Curtis mentioned the interesting moment about the exit costs. There is a trend of growth of those, costs. The increase from year to year, and it's not a linear increasement. It's by exponential pattern those costs increase. So the importance of this aspect is high because government pays so much attention to the environmental aspect of the activities, but the cost of this exit work is also high. Well, we see a gap actually at this point in time of the partnership between the private company and the government. Well, if at earlier stages the government and the private company were, partners, but at the exit station, the company is leaving, so the company wants to maximize the profit from this project, because it relates to those people who work in this area with the potential placement of the recompensation of the damage inflicted on the environment. But for us, we are done. This project is we're done with this project. We want to minimize the cost. So at the terminal point of the project, there is a gap in the partnership relations between the government and the private company, and the developing nations. In the legislature in the developing nations does not regulate relations. Well, someone made a very good analogy saying about comparing changing of the rules in the mining industry with the changing of rules in a football tournament. So, and legal guys in the companies should foresee, so should predict the potential development of the situation. They should talk with the government authorities to prevent emergence of huge problems at the end of the day. And the situation which sits in the middle is the trend, resulting in multi-billion, billion demands to compensate the losses, or to pay penalties relating to alleged violation of various provisions in the law, notably environmental law. More and more we see that government use as a tool to pressurize the private business, not taxation, but environmental laws. In February 2013, State Initiative of Kyrgyzstan in particular defined the ecological claim to a company, a Canadian company, Kumtor, for the amount of $315 million US. And as a matter of fact, they say that the company erroneously dumped the waste. And so, as a matter of fact, considering the earlier claim for $150 million, that amount to $500 million in claims for environmental alleged violations relating to that particular company. The same situation we see in Kazakhstan. which accuses the government accuses the company in wrongful waste management. So they reclassify the waste as not simply waste but as hazardous waste. That's why the cost of handling those cases waste were increased, and in particular the one of the company, Ozermunai Gas, was taken to the say as being violating the environmental applications, and the claim against that made by the government was to the level of $390 million. We can argue whether it is right or not, but we see that it is a trend, and we as legal experts should pay more and more attention to those issues at all, let's say, phases of our activity, be it at the planning stage or while at the stage of analyzing the closure terminal part of the project. I think I have come to the bottom of my section, and thank you very much for your patient hearing. It was a pleasure to be part of this discussion, and I'll be pleased to take any questions and to give you my answers. Thank you. Colleagues, any questions? My name is Olga Chintsova. I'm from Kazakhstan legal company. I want to have a remark to make. Indeed, Evgeny, you're quite right. Well, I understand that we're really short of time. I want to address that ecological issues are so very important, and the huge claims are made to subsoil users relating to ecological issues. And we worked, we spoke in terms about the sulfur waste, and Chevroil were say fined for many millions, and we have many cases, and we are dealing with this. But I would like to say for information, based on each that the Chevroil, last September we conducted a huge vast work which was supported by all Subsoil users to change the ecological laws and to make more streamline the situation relating to penalties, fines, and so on and so forth. And we conducted a survey of foreign laws in this area, and on 30th of May, we'll have in Astana a large ecological forum based on the results of this work. And I want to invite those who are interested to be part of that forum, because subsoil users, oil companies, and non-oil companies will participate, and there will be a lot of interesting proposals made, a review of this code practice. And I would like to confirm that Eugene was absolutely right, saying that this is a trend, and these ecological issues are very important, and we're making progress in Kazakhstan in this area, and we believe that this will be supported. And we invite you all to Astana on May the 30th to this ecological forum. Colleagues, I would like to continue what was started by a colleague from Kazakhstan. I want to say that of late, the development of the legislation in the ecological area has received a boost, and we also developed 6 draft laws. Some of them have already been adopted, some of them are in the process of review in the State Duma, and some of them are at the level of coordination among the federal ministers. Those are the key laws, like laws on monitoring. There are 14 monitoring methods actually involved. This monitoring of the ecological situation in the country. This is the law relating to the prevention of the contamination of oil spills and petroleum products of seas. And this is a draft law on waste of commercial and say consumer waste, and there is also a law on economic stimulation of switching over of the organizations to the best possible technologies available in the moment. So all those ecological pieces of legislation are supposed to play their positive role so that they would be, performing the function of stick and carrot by giving certain preferences to those companies which use the best possible technology. But on the other hand, enhancing or making more stringent sanctions against those who do not use such modern technologies. So these are the general things. But of course, it's always important to listen utterances of the colleagues practicing in this field relating to the subsoil use issues, relating to developing certain rules and regulations in this area. But at the same time, I would like to air some suggestions. We should not be antagonistic in our approach. We should not. No one should see the other party as the, say, a hostile party. I have a presentation ready, and I would be pleased to share it with those. I have a schematically presented listing of all pieces of legislature, which over the last 2 years have either been adopted or were adopted in the first reading and likely to be adopted in the second reading, or at in the phase of coordination among the federal ministries. I regret that we are short of time, but I have this material on a memory stick, and I will be pleased to give to our colleagues and to share it with you so that you can copy on your media and make yourself familiar with this. Thank you very much indeed. All participants will be only pleased to start the next year discussion about the changes which are occurring in the legal field. But summing up, I would like to say that I have formed an impression there are two boats which are approaching each other, if I say. So, well, we said that there are, what about the passengers of those boats? How to strike the common balance of interest? In this way, the role of legal advisors is very important. We today have rather raised issues rather than were able to make a legal analysis of the mechanism of forms as to how this balance of interest could be stricken, could be arrived at. While we know that it's very important that subsoil users work together hand in hand with the state authorities in modifying the laws. This is the order of the day, and I personally believe that the legal forum next year, well, should be devoted to practical implementation of specific projects, and I would like to invite you to speak it in this way. I thank you all for your participation and for your presentation, and I wish you every luck in your endeavors, and I wish you good work at the St. Petersburg Legal Forum.